Family Trusts Part 3, Irrevocable Trusts. Forming an irrevocable trust. Step 1. Determine the need for an irrevocable trust. Assess your estate planning goals and determine if an irrevocable trust aligns with your needs. Consider factors such as asset protection, tax planning, charitable giving, or preserving eligibility for government benefits. Step 2. Choose a trustee. Select a trustee who will manage the trust assets and fulfill the obligations specified in the trust agreement. The trustee can be an individual, a professional trustee, or a corporate entity like a bank or trust company. Step 3. Identify beneficiaries. Determine who the beneficiaries of the trust will be, the individuals or entities that will receive the trust assets according to the terms you establish. Step 4. Consult with an attorney. Engage an experienced attorney specializing in estate planning and trusts to guide you through the process. They will help you navigate the legal requirements, customize the trust, and ensure compliance with applicable laws. Step 5. Discuss and define trust terms. Work closely with your attorney to establish the terms of the irrevocable trust. This includes defining the purpose of the trust, outlining the trustee's powers and duties, specifying the beneficiary's interests, and detailing how the trust assets will be managed and distributed. Step 6. Draft the irrevocable trust document. Your attorney will prepare the irrevocable trust document, also known as the trust agreement or declaration of trust. This legal document outlines the terms and conditions of the trust and includes crucial information such as the trust's name, grantor's details, trustee's information, beneficiary designations, and asset distribution instructions. Step 7. Transfer assets into the trust. To fund the irrevocable trust, you need to transfer ownership of assets from your individual name to the trust. This typically involves changing titles, re-registering accounts, or updating beneficiary designations. Real estate. Execute a new deed, transferring ownership from your name to the trust's name for properties you want to include. Financial accounts. Contact your financial institutions to complete the necessary forms to retitle or transfer ownership of accounts to the trust. Other assets. Work with your attorney to transfer ownership of additional assets such as vehicles, investments, or personal belongings into the trust. Step 8. Sign the irrevocable trust document. Review the irrevocable trust document thoroughly and sign it in the presence of witnesses and a notary public, as required by law. Ensure that all necessary signatures are obtained, including those of any co-trustees if applicable. Step 9. Comply with legal requirements. Depending on the jurisdiction and specific circumstances, there may be additional legal requirements to fulfill, such as filing the trust document with the appropriate authorities or notifying beneficiaries. Step 10. Ongoing administration and management. Once the irrevocable trust is established, the trustee assumes responsibility for managing the trust assets and fulfilling the duties outlined in the trust agreement. The trustee must adhere to the terms of the trust, make prudent investment decisions, keep accurate records, and distribute trust income or assets to the beneficiaries as instructed. Remember, it is important to note that forming an irrevocable trust involves relinquishing control over the trust assets, and changes to the trust terms or structure are generally not allowed without the consent of the beneficiaries. It is crucial to work closely with an attorney experienced in trust and estate planning to ensure compliance with applicable laws and to tailor the trust to your specific needs.